always a pleasure and a privilege to be invited to talk to you and to the audience here at this very distinguished institute. I've heard a lot about the amazing work that the institute has done, and I have high hopes for it flourishing and contributing to the development and reform on an ongoing basis of the Indian insolvency framework. You mentioned the work that we did in relation to MSME insolvency, micro, small, and medium enterprise insolvency. I was at the World Bank in the immediate aftermath of the global financial crisis, helping member governments reform their insolvency regimes. And it became increasingly clear that there was a discrepancy between the sorts of efforts that we thought would be useful to the countries and the ground reality in the countries, virtually all of them themselves. The tools that we sought to introduce to local frameworks were geared towards larger companies, larger corporate debtors. And I'll tell you in a minute why this was the case. But in most of the jurisdictions, I would say virtually all economies, the vast majority of borrowers who were in distress and who might have required the assistance of restructuring and insolvency laws were small, micro entities. Most of them were not incorporated. It was the sole entrepreneur or a partnership, an informal partnership, which did not have a formal legal status, certainly did not have a separate corporate personality independent of the entrepreneurs who constituted and ran the business. And in relation to these sorts of businesses, which constituted the vast majority of businesses and the vast majority of economies developed in the global north, as well as developing jurisdictions in the global south, these were the sorts of businesses which needed to be resolved. So it was a very unsatisfactory state of affairs where we were pushing for reforms which were geared towards the following sort of insolvency regimes. You would displace the management of the debtor. You would bring in an insolvency practitioner from the private sector frequently, sometimes from the government sector, but mostly a private sector practitioner who expected to be paid, remunerated, who would take over the business. A creditors committee would be set up, and then there would be a frequent reference to the court who would take formal supervision and control of the proceedings and who would be referred to at every appropriate stage, but virtually every stage in the insolvency process, from the very beginning when the court made the order commencing the insolvency proceedings to the end where the business was formally disposed of, the proceeds were handed over to the creditors, and the life of the corporate entity was brought to an end. So that was the standard model. And when you think about applying that standard model to micro, small, and medium enterprises, there is a huge mismatch. So for one thing, there would be no corporate entity which could be taken control of by an outsider, by this insolvency practitioner coming in. The business, to a very significant degree, was constituted by the entrepreneurs who were the incorporators, or in many cases, there was no incorporation, who were the people who provided both labor and entrepreneurship, who had the relationships with the customers and the suppliers to the business. Displacing them would be wholly counterproductive because that would effectively destroy whatever value was left in the business, distressed though it might be. So management displacement doesn't work. What about the role of creditors committees? The experience has been, even in the UK, even in the US, in European jurisdictions, that is to say, even in the global north, where there may be more formally incorporated entities carrying on business and taking debt and becoming distressed, to say, even in these jurisdictions, the creditors would generally have small individually small claims against the debtor. So most of the creditors would be trade creditors who would be devastated by the non-payment of the debt owed to them by this entity or this business anyway, and who could not afford to participate on an ongoing basis by holding the insolvency practitioner to account. So they still tend to be disinterested, disengaged from the insolvency process, to expect creditors with small individual stakes who do not have experience or expertise in relation to the process of insolvency to give further time and attention, therefore resources, to participating through creditors committees in the insolvency process, holding the insolvency practitioner to account, scrutinizing the insolvency practitioner's fees and other decisions, and possibly taking legal steps to go to the court to force the insolvency practitioner to act differently. That did not work because it was rationally appropriate for creditors not to participate given their individual stakes. So that didn't work. What about the position of courts? In some jurisdictions, courts are streamlined. So I'm fortunate to participate in the practice of a jurisdiction in England where the courts are extremely streamlined and you can go and get before a court relatively quickly within a few weeks, within a few days in the context of an urgent matter. You can even turn up on the morning and there is the urgent applications list which you can refer to and the court will find a way of hearing you out. That's not the case in relation to the vast majority of jurisdictions in the world. Again, I speak of the global north as well as the global south, of developed countries as well as developing ones. And here, courts they suffer backlogs of cases. There are problems with expertise amongst the judiciary. So, for example, in many civilian jurisdictions, civil law jurisdictions, you would have judges who go to law school, then they go to judge school, and then they go to the judicial bench. They do not have expertise in the sorts of transactions that the debtors have undertaken before ending up in insolvency proceedings. So that gap in understanding and practical nous between the sorts of situations that judges are asked to take decisions about and the expertise and experience of the judges themselves, that creates a huge problem. And that causes the stakeholders in the particular proceedings not to have confidence in the judicial process to the extent that they might have if the judges had more experience. In the global south, these problems may often be exacerbated by the huge backlogs of cases that I mentioned to you. So it may be that you don't get before the court for weeks, months, perhaps even years. The problem here is that often insolvency proceedings are not post-mortems. They are not proceedings in relation to a contract which has gone bad, where the court's role is to look back at what happened, what went wrong between the parties, and allocate responsibility and order the payment of damages. So it's instead of a post-mortem, insolvency proceedings are often emergency processes attempting to save the patient. They are attempting to save at least some part of the business, if that's at all possible, or at least to preserve value in the business to the extent possible, even if the business cannot be saved as a going concern. And this requires speed and efficiency. This requires a streamlined process. And where the courts are unlikely to be able to offer you a proper hearing for weeks, months, or even years, that is a self-defeating process of referring to the judiciary. Also, in relation to both insolvency practitioners and the participation in the process of courts, you require money. You require money to pay the insolvency practitioner, you require money to pay lawyers, and in small business insolvencies, that simply may be a luxury that is unaffordable. So it was for those sorts of reasons that there was a significant gap between the standard insolvency model and the reality on the ground in virtually all jurisdictions. And the governments responded when they realized that the standard model did not address the needs of the vast number of users of the insolvency process. They resorted to ad hoc measures to deal with what were perceived to be these problems. So they removed some of the formal requirements, such as the need to file formal proofs of claim. They shortened statutory timelines, which applied to parties complying with certain procedures within the insolvency proceeding. They dispensed with certain types of stakeholder engagement. So some jurisdictions said that creditor committees need only be created if there were creditors wishing to participate in creditor committees. Otherwise, there was no point in creating these zombie entities which were unable to play any role. So these ad hoc changes were introduced. The problems which still remained and indeed resulted were along the following lines. There were arbitrary boundaries between MSME regimes and standard insolvency regimes. Where do you draw the line? By reference to creditor size, how do you ascertain the size of by reference to the size of the debtor? Whether the shortened, abbreviated process applies or a larger process applies? Is it by reference to the size of the debtor? And if so, how do you ascertain the size of the debtor? Is it by reference to number of employees? But the number of employees might be reduced significantly when the debtor becomes distressed. The number of employees may no longer match the amount of debt that the debtor carries and which needs to be resolved through the insolvency proceeding. So is it by reference to the amount of the debt? But in many insolvency cases, the amount of the debt may be completely out of sync with the nature of the entity. This is true across the board. Special purpose entities may have one or two employees, may have very few physical assets, and nevertheless carry both huge amounts of debt and possibly the huge amount of intangible assets, such as the right to receive repayment from other entities within the same group. So it was almost inevitable and unavoidable that there would be arbitrary boundaries between the MSME insolvency regime and the standard insolvency regime. And then there were rigid preconditions for availability, and there was clumsy and limited functionality of these insolvency regimes, since they were ad hoc adjustments to the standard model rather than a grounds up rethinking of the needs of MSMEs in particular. So it's with that in mind that there was a coming together of 8 scholars, judges, and practitioners from civil law jurisdictions and common law jurisdictions, including Canada, the UK, Spain, Germany, and Italy. We came together in what was called the Bowen Island Group to rethink from the ground up the needs of MSMEs. And we thought that it would be appropriate to unpack what happens, the roles which need to be played in any insolvency proceeding. And we thought that there were 3 types of roles which needed to be played. There was the judicial function, which is about adjudicating disputes, most importantly. But we also knew that the time of the judiciary is a precious and scarce resource, which needs to be allocated appropriately, especially in jurisdictions where there is a backlog of cases. And you don't want to have formal need for the judges to decide particular points, when in fact, in reality, if you involve the judges, that would just bring the entire process to a standstill because of the slow rate at which court processes move. So there was a judicial role. The second was the management role, that is, who makes day-to-day commercial decisions within the distressed debtor business while the business is going through the process of insolvency. This could be done through a variety of mechanisms. You could leave the pre-distress entrepreneurs or decision makers in place. So the debtor in possession regime that we are familiar with from US Chapter 11. You could displace the pre-distress management and put in the insolvency practitioner, the model that I talked to you about a couple of minutes ago, the standard model that we operated with at the World Bank. Or you could have somebody who is employed by government to take over. So the official receiver in England takes over and responsibility as the liquidator when winding up order in relation to companies first made. So there might be problems here as well. If the jurisdiction is resource poor, it may be that to consign a business to the decision making of an official receiver or other government employee may be as problematic for the same sorts of reasons as consigning the judicial responsibility to the judges, slow process, poorly resourced and inexperienced decision makers, and so on. And the third role, so judicial functions, you had managerial or management functions, and then there were administrative functions. Administrative functions are who provides the documents which might be used in the insolvency proceeding, who ensures compliance with timelines, who decides that compliance has occurred in the absence of disputes. If there's a dispute about whether compliance has occurred, then you may have to go to court. But in the absence of such a dispute, it may be an administrative decision that compliance has occurred, a form has been filed, or all of the creditors have been duly notified of a particular stage in the process. So take these three sets of functions, the judicial, management, and administrative functions, and allow the stakeholders to decide which of those functions needs to be discharged and which of those functions can be deemed to have been discharged depending upon the circumstances of the particular insolvency. That is to say, you don't need to involve the court at all, we proposed, unless there is a dispute. If there is no dispute, then the process can be an entirely administrative one. Don't involve an insolvency practitioner unless creditors ask for such an involvement and the debtor's estate has sufficient value to pay an insolvency practitioner to become involved. So, for example, creditors might take the view that they can't trust the existing debtor and its decision makers. So they need an independent person to come in, take control of the business, look at the books and records of the company and see where the money that the creditors had provided, where that money has gone, perhaps to take proceedings on the debtor's behalf within the insolvency process for recovery of that money which may have been misappropriated. That's fine. That should be an option. But in most cases, that simply would not be necessary. And even if it were considered to be necessary by some stakeholders, there may not be money available in the estate for somebody to be paid to do that. In those sorts of circumstances, requiring the involvement of an insolvency practitioner would be self-defeating. It would just bring the process, it would grind it into the ground. So leave it to the stakeholders to make the request to have a particular outsider involved, whether it be the court, whether it be lawyers, whether it be insolvency practitioners. Otherwise, create a streamlined process which is based on administratively administered standard form plans or processes, which has a bias in favor of the continuation of the small micro business under the pre-existing management, people who would be the be-all and end-all of the business in the way that I described a few minutes ago, leave them in charge, and take into account that in many cases they would have guaranteed the debts of any corporate entity which may be involved in this business. So banks would often take personal guarantees from the managers and owners and directors of the business before they lend to the corporate entity. In those cases, the MSME insolvency framework needs to dispense with this false dichotomy between corporate insolvency mechanisms and natural person bankruptcy mechanisms. Rather, there needs to be a more joined up response to provide discharge for the natural person, entrepreneur, who has become distressed through no fault of their own, because most insolvencies in most parts of the world do not occur as a result of misappropriation of assets or wrongdoing. They happen out of bad luck because it was a bad idea, or it was a good idea, but the world moved on and the business did not change, and so the business proposition is no longer viable. So this was our idea about allowing the stakeholders to make decisions about which of the traditional insolvency law rules to engage in a given insolvency proceeding, depending on their assessment of the particular needs of this case. And we developed this at book length in the MSME insolvency book that you will be able to find if you look at Amazon or a good bookshop in your neighborhood. So that's the basic introduction to the idea, and I'll stop there. And I'm very happy to take further questions or criticism. I would really like challenges to the basic view, so we can talk about that, or perhaps the Indian experience itself, and we can discuss particular features of the new Indian pre-pack that you've just had introduced a few days back.
Right. I think that was a pretty interesting opening remark, Dr. Mokel. And what you spoke about is that MSMEs are structurally different from other big corporations, right? So you cannot apply the same old practices to MSMEs. You need to create a new sort of, you need to come up with new solutions to address the problems that are particular to MSMEs. But what you spoke about are the three roles that are usually there in an MSME: the admin role, the management role, and the traditional role. But one interesting point that you mentioned, that you should allow the stakeholders to, decide which role is important and who should then go about doing that particular job. But don't you think in a common law country like India specifically, where everything is taken to courts and there are so many litigations, having such open-ended framework will ultimately lead to more litigation, and as a result there will be more delays in the process? Because what the Indian framework speaks about, they have given very categorically as to when the resolution professional comes in, who has to appoint the resolution professional, what is his role. So all these have been laid out in the ordinance that I was talking about earlier. So don't you think keeping it open-ended will actually lead to more problems than actually solving the issues of MSMEs?
Rustam, that's a very good and important question. So I mentioned to you that the model that we put forward has a bias in favor of a particular default process. So there's a default process, which is no courts get involved, no insolvency practitioner gets involved. The idea is to allow the business to continue on the basis of a standard form plan proposed by the natural person entrepreneur. And if I'm right in suggesting that in most cases, creditors are rationally disinterested, they do not have any particular need to go chasing after a small individual loan, or even if they would otherwise have wanted to go chasing after that small loan, they think, actually, I know that the business became distressed and it genuinely does not have more than the value that the entrepreneur is proposing to repay, let's say 50 cents on the dollar or what have you, 50 peso on the rupee. In those circumstances, there may be no challenge. And the point would be not to have a requirement in those cases, still for the appointment of the insolvency practitioner, still for the need to instruct lawyers to go to the court and wait for the court process to get cleared. The court only gets involved if a creditor thinks, hey, wait a minute, I'm owed a significant amount of money, and I think that there's been wrongdoing. And I think that the person running the business is a crook who's misappropriated funds, who can still pay back the money, but who's choosing not to pay. I want to do something about that. Well, in those sorts of circumstances, in a rule of law governed country such as India, you would have to provide the mechanism by which the aggrieved creditor should be able to invoke, in this case, the court's involvement. It may be unfortunate, but the opposite view is to say, well, people who generally think that their legal rights have been trampled upon, in this case, the right to be repaid on the loan that you made to this business, that they should be prevented from going to court. That would be a very dramatic step. However, we also suggested that the debtor should have the right to apply to have the creditor's petition or application dismissed on a summary basis on the ground that the application was hopeless, that the creditor had not substantiated their reasons for thinking that the business had become distressed for bad reasons, for reasons of misappropriation or misallocation of the debtor's property, as opposed to misfortune, for which you may lament that misfortune, but you don't go to court to seek redress against it. It's just one of those things which is part and parcel of engaging in commercial activity. You take a risk. So it's from that point of view that your challenge is absolutely right, that it potentially creates a problem, but we have responded to that in those three ways, which is there is a default process. So the default process is non-involvement of courts. Then there is an acknowledgement of the rule of law requirement for parties who are aggrieved to go to court. But then there is also this option to apply to have the application of the creditor struck out on the basis that the creditor has failed to meet whatever may be the appropriate criteria for showing that there is, let's say, an arguable case, or whatever the standard may be, that it's more than a merely fanciful prospect, those sorts of tests that English courts use to dismiss claims on a summary basis. So those are various levels of responses to the real problem that you highlight.
So you mentioned that when there is a default, the court involvement is not there, because obviously there's a default, and accordingly the process moves forward. But the ordinance that has been proposed in India, which has come out in India, they have set a trigger limit of 10 lakh rupees. So if there's a default of 10 lakh or more, then you can go for a pre-pack insolvency. But what I feel is that the entire idea of a pre-packaged insolvency is to resolve and identify the stress as soon as possible, right? In the least amount of time with the least cost involved. But then we have prescribed that to initiate a pre-pack insolvency, you have to apply to the adjudicating authority to get an order passed. Now, what about the delays that will happen? Suppose there are a flood of cases that come in, and just to initiate an insolvency, pre-pack insolvency, there is a considerable amount of delay. So do you think that is actually solving the purpose, or shouldn't have there been any such criteria where you need to apply to the adjudicating authority to initiate a insolvency for an MSME?
Risam, can you help me? Is the adjudicating authority different from the standard courts? Is it a different mechanism, or is it a circuit or a bench within the standard courts?
No, so these are the national company law tribunals that we have in India. So they are handling cases of Companies Act, the normal thing, the CIRP under normal IBC, and now they have also been given the additional responsibility of MSME insolvency. So they are already burdened,
So,
like
And
Neetiman mentioned earlier.
just
So they're
yeah,
right.
and just to add to that, Professor Merkel, these are like commercial courts in England, which looks into the commercial
Mhm.
matters. So these are primarily commercial courts.
And are they as burdened and are they slow to take on and tackle cases as the ordinary courts are?
Uh, I have not done any statistical analysis, but my knowledge so far would say definitely yes. And the reason
Mhm.
is because there are, NCLT became functional, and correct me if I'm wrong, anyone here. Pulkit, you are here, and just to let you know, Pulkit is our friend and also an IP insolvency lawyer, and he was
Mhm.
in, he's working in England too, so he has experience in both the countries. So Pulkit, please fill me in case I'm wrong. NCLT commercial courts in India. Initially we had CLB, called Company Law Board, which is not like an adjudicating authority, just like a tribunal. So NCLT, got more nuanced, a more diverse work and power, and it became functional after coming of IBC. Pulkit, My guess would be that they are more burdened. What do you think?
Hi, hi, Neeti. Can you hear me?
And Professor
Hi.
Yes.
Mokul, he's also UCL alumni, by the way.
Hi, Pulkit.
Hi. How'd you do? Um,
Good, thanks.
yeah, they are quite burdened. But okay. Well, the answer is actually not simple. But the first trouble is that we don't have a permanent chairperson. The rules provide that a chairperson needs to be a retired High Court chief. So one of the chiefs of either of the high courts has to be the chairperson. We don't have one at the moment. What we've got is Mr. Prakash Kumar, who used to be the technical member at CLB, and he used to sit with Justice Deshmukh, um, who is now the chairperson and a judicial member. That's one problem. The second problem is that even our National Company Law Appellate Tribunal, which falls directly below the Supreme Court in hierarchy, also doesn't have a permanent uh, chairperson. So, well, there are those problems of appointment of members onto the tribunals, and that's of course trebled by a number of petitions, public law, on the administrative side, challenging appointment procedures and who should appoint and so on. So there's a lot of politics that surround the appointment. So we don't have enough members at the moment, enough judges to deal with these situations, and the ones that we do have fit right into, well, the situation that you explained, i.e., a lack of expertise. So those are the practical problems. So what I've found is that your easy, simple, low-hanging fruit type applications are dealt with quite quickly. In fact, very quickly. But your complex matters are not, and they just keep sort of hanging for months on end, if not years, for those
So,
reasons, essentially.
Pulkit, that's extremely helpful. So, two things to say. First, what you describe is very familiar from many jurisdictions. As you know, this is not a problem peculiar to India at all. Um, Appointments to these bodies become very contested, very problematized for a variety of reasons, politicized, but also commercialized in a potentially inappropriate way. So it's problematic. So I understand that, and I've seen this phenomenon elsewhere. The reason I asked this was that I asked Rustam this question is that our experience with pre-packs, which do not involve the courts at all, unless there is a complaint, our experience with pre-packs has been bad in those circumstances where the business is sold to a new company which has been incorporated by the owners of the old company whose business it is. In those circumstances, there is, I would say, a corruption of the process. In England, I'm talking about a corruption of the process whereby the owners of the old company which is unable to pay its debts will go and find a compliant insolvency practitioner, then make an appointment out of court of this insolvency practitioner as an administrator. And the administrator, within hours or days of taking up office as a result of this appointment, would use their statutory powers to bring about the sale of the business to the new company which has been created by the owners of the old company. The bank, which has security, is paid off in full, but everybody else is just screwed. This includes the employee creditors who are owed for back wages and pension contributions and so on. This includes trade creditors who may be particularly badly hit. It also includes the revenue, the tax authorities. So these types of credit are badly hit. So as a basis of my study, including empirical study of this in England, and I would say the UK, because similar findings apply to the other jurisdictions in the UK as well. I'm very wary of saying that the courts should be dispensed with at all, altogether, and that there should be a particularly high burden lying on those wishing to challenge a pre-pack. So it's unfortunate, and what you describe and what Pulkit describes is being stuck between the proverbial rock and a hard place. Um, but I can't see an easy way out other than trying to, this is the efficiency of the judicial authorities or frameworks or finding alternatives. I can't think of a way in which you can dispense with the right to challenge the pre-pack. Perhaps, Niti, you don't have to have the initial application to commence the pre-pack, but what you do need is, in my view, based on the experience of the UK pre-pack, which does not have any judicial involvement except ex post and on very difficult grounds. A person seeking to challenge a UK pre-pack is in a very, very legally difficult position to bring the challenge, and they would not have the information which they require. They would not be able to hold the insolvency practitioner to account. On that basis, I think that before the pre-pack is consummated, before the business is transferred or the significant assets of the business are sold off, there has to be some mechanism ex ante, not ex post, for there to be an appropriate judicial or quasi-judicial assessment or explanation. So yeah, I'm very much shaped by my experience of and understanding of the UK pre-pack, which in those circumstances which I've described is terrible. And by the way, I should say most of the UK insolvency practitioners would at this moment be very much up in arms because they think that things are generally hunky-dory and everything is fine and this is just a misunderstanding of the process. So what I just said to you is a controversial proposition within the insolvency practitioner profession, but I can point to my empirical research, which is the largest research on English insolvency proceedings ever carried out, which compared proceedings in 2003, administrative receiverships, with administrations and both standard administrations and pre-pack administrations in 2012. And it's quite clear that the pre-pack is a disaster, particularly where it involves the owners of the distressed company buying the assets.
Professor Mockel, do you mind if I just ask you a quick question?
Please.
Yes, thank you. Why do you think pre-pack was so popular with IPs in the UK?
Well, let me take a cynical view.
Yeah.
Suppose that you are told that you are approached and you are offered a lucrative appointment. Can you hear me, Pulkit? Can you hear me still?
Yeah. Yes, I can hear you, but your video is now gone. At least on my side, I can't see you. I don't know whether others can. Yes, we can see you now. Well, I can see you now.
Okay, great. Great. So if you are approached by the owners of a distressed business and offered a potentially lucrative appointment, but you're told that if you jump through certain hoops and you reach the conclusion using your independent judgment that the best buyer of the business is the company which has been set up by the owners of this old distressed company, you don't have to do any particular due diligence. You can base yourself on a desk valuation, which your firm carries out and gets paid for as well, or a related entity carries out. You can base yourself on desk valuation. You don't have to expose the business to the market. You don't have to do the, disturbing legwork of trying to find the best buyer for this business, the sorts of things which insolvency practitioners would do in the standard case. Soon after appointment, you will just bring about this preordained and predestined sale, which is not predestined because you're an independent professional and you are using your statutory judgment to reach the conclusion, which happens to be the conclusion that the person appointing you wanted you to reach ex ante. that the company that they have set up is the best buyer, well, why would you not take that appointment? I mean, what's there to lose from your point of view? So I think that this is the most obvious, and in some cases, the most obvious explanation is also the right one. And this is the obvious and the right explanation in this case. There isn't any other. It's not that there is any evidence suggesting proper evidence other than really embarrassing so-called evidence suggesting that pre-packs perform a useful role in relation to these entities.
Well, just to follow up, that is, of course, I think that does, of course, explain as to why IPs were so keen to accept such assignments when they came up. But you see, what I found was that IPs were also keen to reject trading administrations, trading insolvencies, otherwise. And I wonder whether you've given any thought as to why that was.
Now, that is a very good question. And I think that there are sociological, commercial, and legal reasons for that. It's a combination of those. Some cases, one would be more important, in others, another, but all are in play. Sociological reasons. The IPs who became administrators and were given the option of trading the company through the administration with a view to rescuing the company's business as a going concern. These were the very people who, until the Enterprise Act 2002, which came into effect in September 2003 in the UK, these were the people who had been operating as receivers beforehand. And as receivers, their orientation was towards the interests of the bank, which Quay's secured creditor appointed them. They had no interest in and no responsibility for the rights and interests of non-bank junior creditors. And they had no reason to develop an expertise in or a reputation for being able to save the business as a going concern. Some businesses were saved for commercial reasons. There were huge, significant, viable businesses, even though their capital structure no longer cohered with the ability of the business to generate sufficient revenues to meet those debt obligations within that capital structure. But nevertheless, the business was viable, so it got saved. But otherwise, these receivers had no incentive to develop their expertise in trying to save the business. And then these receivers, on the strike of midnight, 15th September 2003, were now to act as administrators in the new form introduced in 2002. They were to act as administrators. The first option that they had to consider was the rescue of the business of the company as a going concern. That is, its business within the company being rescued as a going concern. These were the same people, and so they did not have any expertise. They thought that this was an imposition on them. They were not persuaded that receivership had been a bad idea, which in my view, and again on the basis of empirical evidence, it was. And so that was the sociological reason. The commercial reason is that frequently it simply isn't possible to continue to trade the business unless there is sufficient money. And the main form of money which keeps a business trading through difficulties is trade credit. That is to say, your suppliers should supply you with your raw material, then give you 30 days, 60 days, 90 days before they get paid. And you use the raw material to do your thing, sell to your own customers, recover from your own customers, and then repay your suppliers. So that's a sort of trade credit. That's the crucial form of business credit for most MSMEs. But even the administration mechanism does not, or did not, it's recently changed, but did not curtail the ability of counterparties to terminate contracts simply for the reason that the company had entered into insolvency proceedings. So unlike Chapter 11, which had that avoidance of so-called ipso facto clauses and also precluded counterparties from terminating contracts as long as the debtor in possession was able to cure any pre-existing defaults, etc., or provide the equivalent of a cure. There was nothing like that in the administration process. So commercially, it was not possible, through the combination of those legal and commercial reasons. It was not possible to continue to trade the company because the company simply did not have money. And the bank would not support you. The counterparties would terminate their contracts, and then third parties, other counterparties would not give you trade credit sufficient to allow you to continue to trade. So it just practically, including legally, it was just not viable to continue to trade. So in my view, those are the sorts of reasons which made IPs understandably reluctant to opt for trading administrations. They happen, but so for example, in my sample, it's something like fewer than 2% of the cases of administrations are trading administrations. So, minute fraction.
Thank you ever so much, Professor Markle. That was enlightening indeed. I know Aurelio has posted a really long question, so I won't follow up with another. So thank you.
In fact, Aurelio, would you like to speak in to the mic?
Professor Aurelio, we would love to hear you and see you. So please.
Hi, Aurelio.
Hello, everyone. Reese, great to see you.
And you.
It was a long time
Although I
since
can't
you
see you
kindly
so far.
welcomed me in London. Yeah. I saw that you were invited to speak today, and I couldn't miss the opportunity to learn from you as usual. And actually, I would like to hear your views on two critical issues in the context of SMEs. The first one is about the lack of viability of many SMEs. The data seem to reflect that the percentage of non-viable SMEs is probably higher than the percentage of non-viable large companies, probably due to the lack of resources to obtain professional advice in an early stage, or maybe because of the low going concern value of some of these companies, or for some other reasons. The truth is that many of these MSMEs don't seem to be viable. And some of them may want to try a workout first before even considering a formal insolvency process. But we are observing that some countries, including Australia, including Singapore, including Myanmar, even India with the pre-pack, are adopting these simplified reorganization procedures. And one of my main concerns with these procedures is that maybe could be used by non-viable MSMEs, even in good faith. Sometimes it's just because they don't know that their company is no longer viable, and they still want to try this simplified organization procedure. So do you think that is a real concern? And if so, how would you address that problem? What would you recommend to regulators and policymakers adopting these simplified reorganization procedures, and how to make sure that we prevent these non-viable SMEs from using these procedures? And the second question is about one point that you have kindly mentioned, which is the discharge of debt for individual entrepreneurs. So as you know much better than all of us, many countries around the world don't still provide individual debtors with an effective discharge of debt. Do you think that's a desirable policy for all of them to implement this discharge of debt? And so what some authors have suggested is that discharge of debt should apply only to honest but unfortunate debtors. So how would you define these honest and but unfortunate debtors in order to make sure that the discharge of debt is not used opportunistically by individual entrepreneurs? And also, would you extend the discharge to shareholder managers of small companies, SMEs, acting as guarantors, for example, of the company's debt? So in other words, would the discharge make the guarantees or security interest disappear, provided that the MSME company can qualify as an honest but unfortunate debtor? Sorry for the many questions, Reese, but I know you know that I consider You're one of the world's leading experts on these issues. So that's why I would love to hear your views on that.
Really excellent questions, really, and very thoughtful ones, and they have real purchase in the real world. They are a real issue. Both highlight real issues in economies and jurisdictions around the world. Let me start by talking about viability. You used this notion of viability. What do we mean when we say that a business is or is not viable? The most important understanding of viability is we can say economic viability. That is to say, are the assets which constitute the business able, if harnessed together as a going concern, to create sufficient value to repay? No, let's talk about the most fundamental notion of viability, which is, are they, if they are the assets, which include land, which includes capital of various sorts, machinery, as well as money, which includes the labor of employees, and which includes entrepreneurship, the traditional productive services or factors of production that economists talk about. The first question is viability. Viability is if harnessed as a going concern into this business, these productive services create more value than would be created if the going concern were to be stopped and the assets were to be split up from the going concern and put into the market individually into a new, different use. If they are more valuable as a going concern than they would be if split up and dealt with in the market individually, then there is fundamental economic viability. All of the stakeholders, including society as a whole, are better off if this business is allowed to continue as a going concern. Why? Because any other alternative use, by hypothesis, brings in a lower aggregate amount of value than is being generated by these assets in their present use in this business as a going concern. So that's the most fundamental notion of viability. The problem arises when a problem arises when the value which the business is generating, while still more than would be created by alternative uses of the constituent assets of the business, nevertheless, that value is insufficient to pay off the debt obligations that the owner of the business has taken on. So there is a discrepancy between the value which is being generated and which society values, because it's more than any alternative use of the constituent assets of the business. It's still not sufficient to meet all of the debt obligations as they fall due. So that's the fundamental problem. And the role of insolvency law is to try to identify those businesses which are still viable. That is to say, the constituent assets create more value harnessed to this use than they would if taken away from this use and put to other uses. So insolvency law should identify those viable entities, and it should provide for a mechanism by which those entities can be preserved as a going concern, whether under the present management or a new management remains to be seen. So that's the fundamental problem. Now, how do you ensure that insolvency law only provides a second chance to viable businesses? And the most important mechanism, from my point of view, is to vest the decision as to viability in the parties who know this business best and who have a direct economic stake in getting the decision right. That is, the decision whether to preserve this business as a going concern or to split it up and put the assets which used to constitute it in the market on a piecemeal basis. So who are these people who know the business the best and who also have a personal stake in the outcome? It's not the insolvency practitioner. The insolvency practitioner, if there is one, has just been parachuted in upon the commencement of insolvency proceedings. It's not the judge. The judge would have no personal knowledge of the way in which this business was run, would have no view on the quality of the management and the probity of the managers. would have no understanding of the particular sector of the economy in which the business must compete and find its commercial role. So it's not the judge. So what about the entrepreneurs themselves? They would presumably know, but they would obviously be biased. They would have an incentive to say this business is viable and we should be left in charge of it because that's the way their bread is buttered. That's the outcome which serves their personal interests the best. So who's left? In my view, it's all of the creditors as a group. These are the people who've transacted with the business in the relevant sector of the economy in which the business operates, who have transacted with the business as the business declined from relative health, one presumes, into distress and then insolvency. And these creditors have an incentive to get the decision right. Because if the business is more valuable as a going concern than it would be if the constituent assets were disposed of piecemeal, if the business is more valuable, then these creditors had better get that decision right, because that is how they get paid more than if they were to opt for the piecemeal disposal of the, or on a breakup basis, of the constituent assets. So that is the reason why it makes sense, in my view, to vest the decision, restructure or permit continuation, or liquidate, do not permit continuation, to vest that critical insolvency law decision in the creditors as a group. They are the only constituency as a group who is appropriately placed to make that decision. However, we then have the point which I described towards the beginning of my comments about rational disinterest. Most creditors would be disinterested. Many would not have any particular expertise in solvency processes. And so you then have a problem about drawing on the expertise and inside knowledge of these creditors as to the status of the business. So how do you deal with that? You strike a balance in relation to MSMEs in the way that I suggested. That's my view anyway. So you say the presumption is that the business continues because the presumption favors people whose interest is to continue the business, namely the entrepreneurs and the employees of the business, if there are any, etc. So allow the business to continue, but subject to a powerful veto vested in the creditors as a whole. So any creditor with a sufficient claim should be able to throw a spanner in the works. And if the spanner survives the motion that I described to you, that the debtor can file saying the creditor says that the business should be liquidated because it doesn't have sufficient value, but actually the creditor hasn't substantiated that. Subject to that sort of motion for dismissal, if there is going to be one, the creditor should be able to stop the progress of the reorganization of the business. The business should be the life of the business should be brought to a peaceful end, and the constituent assets should be put back into the market to find better uses. So that's the way I think that, and that's why I think that shutting out creditors as a group is fatal, because it short circuits this crucial mechanism for deciding whether a business is viable or is non-viable. So that's how you deal with that. And then in relation to discharge again, in my experience, and I've worked personally in about 20 jurisdictions other than the UK, on the ground, talking to stakeholders from all of the relevant sort of stakeholder constituencies. My experience is that most insolvencies in most parts of the world do not result from misconduct. They result from misfortune. And in those circumstances, creditors would still be mad. They would still want to be repaid. They might have irrational but very human and understandable emotions of the sort that we have about the entrepreneurs. They may be very vindictive towards the entrepreneurs, but in most cases, while understandable, those views are irrational, they are unsubstantiated, and they are unsubstantiable. And so the natural person entrepreneur who's also become indebted should not be prevented from obtaining discharge simply because there are going to be, in most cases, these sorts of understandable but unsubstantiable feelings that creditors harbor. However, a significant minority, depending on jurisdiction and time of the state of the economy, the proportion might differ. A significant proportion of insolvencies result because of misconduct, misappropriation, culpable negligence or culpable recklessness or culpable misuse of the privilege of limited liability. And in those circumstances, it's absolutely critical in order, well, just to vindicate the rights of the parties in an appropriate way, but also to maintain the credibility of the system for these sorts of entrepreneurs not to be allowed to have discharge until the court is satisfied that these entrepreneurs have given, at the very least, given full disclosure of their own assets and have coughed up any assets that they may have squirreled away from the business, or indeed transferred to their loved ones or their connected persons. And so once again, you vest the decision to challenge the discharge of the natural person entrepreneur in a creditor. So the normal default position is that that the entrepreneur would get discharge, but that is subject to a challenge by a party who considers it worth their while to instruct lawyers to go to court and challenge this. Is that ideal? Is that the best of all possible worlds? No. There are costs to this approach. But in my view, the costs to this approach, the net costs to this approach, taking into account the benefits, are the smallest compared to other reasonably practicable approaches that we could think of in the real world, where every approach has costs. So that's my very sort of abbreviated response to your very thoughtful question, which requires, in fact, a much more detailed and reflective response.
So thank you so much, Rhys, for such a wonderful response. I very much appreciate it. And as you know, it's always a pleasure to learn from you.
Very nice to see you, Aurelio.
There is another question here from Connor. He says, do you think there's a real risk that asset disposal to connected parties can discredit any simplified insolvency process? If so, should they be prohibited?
Yes, first of all, hello to Connor. It's been a long time, so I hope we can catch up in person in due course. So it's nice to see you in this forum. So that's the first and very important point from my point of view. The second, in my view, there is a very real risk that asset disposals to connected parties can discredit simplified insolvency processes, and that they should discredit those processes in circumstances which, on my research, prevail in the UK in relation to pre-pack disposals to connected party entities. And I say that for a number of reasons, and I'll just pick some of the more important ones. When you compare controlling for all other factors, including in particular the size of the company and the debtor company and the sector of the economy in which the company operates, and the time within the life cycle of the economy, whether the economy is in distress or as a whole is in distress, or whether the economy is booming, which also has an effect on the efficacy and success of insolvency proceedings. When you hold all of those sorts of factors constant, you control for those factors, and you compare pre-pack disposals with ordinary disposals of businesses, and in particular focus on pre-pack disposals to connected party entities, that is, new companies created by the very people who used to own the company whose business is to be disposed of, for the sorts of reasons that I've just mentioned to you, I mentioned to you a few minutes ago. You find that lower value is realized. So third-party buyers of the business pay more than connected party buyers for the same sorts of business connecting for other factors. The distribution to creditors is lower. So it's not just that money coming into the insolvency estate is less, but money then being paid out to the stakeholders, the creditors, is also less in connected party transfers, pre-pack transfers to connected parties. The costs of the proceeding are higher, controlling for other things. If you think about a pre-pack, you would think, well, most of the stuff was done already. The insolvency practitioner does not have to go around trying to find a buyer. It doesn't have to expose the assets to the market. So that should presumably take up less effort and less time, and the proceedings should be less costly when all of this has been preordained in the pre-pack. But actually, the costs of the insolvency practitioner, taking into account the pre-appointment costs, are higher, controlling for other factors. So how do you explain this particular finding? I explained it on the basis that insolvency practitioner is taking a premium, knowing that it's going to be in his interests he's doing a favor for the pre-existing, the owners of the current business, and he's effectively taking a kickback. So that's how I explain the higher costs, because it's difficult to explain them otherwise on the basis of the nature of the tasks which need to be performed in pre-pack and non-pre-pack proceedings respectively. And finally, we looked at failure rates of the business after it's been transferred. And Aurelio would be interested to hear that businesses which had been the subject of a pre-pack disposal to a connected party entity tended to fail quicker and more frequently compared to businesses which had been the subject of a third party sale through the administration. And the explanation is the obvious one that I gave to Aurelio, which is that the crucial mechanism of deciding whether the business is viable or non-viable is the participation of the creditors as a group. The pre-pack short circuits that participation. It also short circuits other potential mechanisms for sifting between viable and non-viable businesses, one of which would obviously be the exposure of the business to the market and seeing whether there are buyers in the market for the business. So once those sorts of mechanisms are short-circuited via the pre-pack, you have a higher failure rate and a quicker failure rate, which has deadweight costs for the economy as a whole. So for all those reasons, in response to Connor's question, asset disposals to connected parties can and should discredit insolvency processes of the UK pre-pack format, unless there is an appropriate mechanism, exposure to the market, participation by the creditors in some form, perhaps through a simplified vote, and or some form of judicial intervention. Those are the three mechanisms by which to control this sort of misfiring of the insolvency process. So unless at least some appropriate level of one or more of those processes is present, you will have the potential for the regime to be discredited. Back to you.
Yeah, so Professor Mockle, I think we have exceeded our time, but the discussion is so interesting that there are a couple of questions more. So if you don't mind, can we take them up?
Yes, of course, I'm happy to take them.
Yeah. So there's a question by Professor Van. He says that has UK put in place professional codes for the insolvency practitioners so as to mitigate some of the abuses that take place in relation to pre-packs?
Yes, thank you, Professor Wan, for that question. Yes, so I'm sure you'll be familiar with the SIP 16 code, which is a statement of insolvency practice, which is agreed amongst the regulatory bodies of insolvency practitioners, which requires the IP who is going to do the pre-pack to run through certain formal hoops. So that's one set of codes which has been put in place. And then there was a review of the pre-pack a few years ago under Theresa Graham, the Graham Review. And as a result of the Graham Review, a so-called pre-pack pool was created by which um, experts, within quotation marks, could be asked to opine on the proposed sale of the business to the connected party entity which was going to buy as a result of the pre-pack. So I mentioned to you that there are three mechanisms, in my view, for controlling the problems which arise if you try to short circuit those mechanisms which exist to sift viable from non-viable distressed businesses. I said those processes are exposure to the market, participation by the courts, and appropriate participation by the creditors as a group. And the Graham Review proposed this fourth possibility, which was this group of experts who could be asked, some of whom could be asked to opine on the propriety of this mechanism. Now, this was a charade. This was I thought this was on any view, even on the most basic analysis, this was a completely wrong-headed proposal for the following sorts of reasons. These experts owed no duties to anybody, any of the parties. They did not owe duties to the creditors as a group or to the insolvent company or to the insolvency practitioner or to the court. They could not be held to account for not reaching the right decision. They did not have any reason for developing a reputation for scrupulous scrutiny. If one of these people in this pool developed a reputation for saying no too many times to proposed sales, they would simply not be asked next time around by the insolvency practitioner. So the incentives were all wrong. This was just a facade. And so this had been set up, and this was reported on a couple of times, and the government is now proposing, it's just taken powers to further regulate the sale of pre-packs to connected parties. But in my view, no such mechanism, and the most recent proposal is, in my respectful view, terrible as well in the UK. For the same sorts of reasons as I just mentioned in relation to the pre-pack pool. So in my view, unless you introduce an appropriate combination of the three mechanisms I've mentioned, court participation, creditor participation, exposure to the market, you're not going to have viability and credibility in the process. Back to you, Rustam.
Yeah. So we have a question from Shashwat. Shashwat, if you could unmute yourself and speak your question.
Yeah, hi. Am I audible?
Yes, we can hear you.
Yes, you are.
Hello, sir. So my question was, for example, if a resolution plan or pre-pack, the implementation of the plans of the pre-pack is the utmost importance to any insolvency law or IBC, which is the Indian Insolvency and Bankruptcy Code. So what I was thinking of is, for example, if the new party or the new management or the old management which comes from pre-pack is not able to implement the plan or pre-pack, so what shall be the measure that should be put in place to make sure that it happens? Because if the same is not implemented, the value of asset will deteriorate over a period of time. So what can be done to make sure that they are implementing the same? Because there have been instances where they haven't implemented the pre-pack or the resolution plan. Not the pre-pack because it's came now. The resolution plan hasn't been implemented. So what shall be the measures that can be put in place as per your?
Shashwat, good question. Thank you. So I think that you need to distinguish between different types of companies here. Large companies would have two factors which may not be present in relation to very small companies. Large companies may have a reputation to maintain. And if they treat their pre-existing debtors, pre-existing creditors badly, then they might find that they are frozen out in the market from doing business with the best counterparties. So there's that sort of reputational concern that at least some large companies would have. Others may not have that concern because there may be plenty of alternative counterparties with whom to do business. So that's at least one potential factor. The second factor would be that large companies would have a sufficient value for the appointment of an implementation monitor of some sort, a supervisor or implementation monitor, and various jurisdictions have provided for that mechanism. We have it in relation to the CVA supervisor. The new Dutch scheme process has the possibility of an implementation supervisor who can go to the court on an expedited basis if they take the view that the debtor's management has deviated in material respects from due implementation of the plan, or if they are misappropriating property of the company, etc. So large companies would be able to, the stakeholders of large companies should consider providing in the plan for the appointment of these sorts of professionals who have these powers to go to the court in appropriate circumstances. The problem is going to be, as so frequently with MSMEs, where the reputation may not be such a big concern, and or the value in the estate and the value at stake may not be sufficient to bring in a thorough, competent, scrupulous professional who keeps a close eye on the implementation of the plan and who has responsibility and right to go to the court if things start to go wrong. And in these circumstances, the best of a sort of a bad set of circumstances is you empower creditors who consider that the implementation process has gone off the rails to be able to go to the court or the other adjudicative body and to complain about that and to have redress. Again, this, to emphasize, this is not ideal, but given the alternatives available in the real world, this seems to be the best that I think we can think of.
So the issue that is coming in here is, for example, the resolution plan is only be shown to the NCLT, the financial creditors who are becoming of the member of the COC, and the resolution applicant. So it's not provided to all the stakeholders. So how will they be able to understand whether things are going as per the resolution plan or not?
Now that I did not know, and that is really that's quite a problematic feature. I didn't know that you had this feature in the law there. So if I contrast this with the UK scheme and restructuring plan, the emphasis is on the provision of all relevant information which would be required by creditors in order to make up their mind whether to vote in favor of or against the plan. And the court will often turn down the company's request to call a meeting of creditors if the court considers that the information that the debtor proposes to provide to the creditors is inadequate. Now, if the information to be provided to creditors is limited, or if there is no obligation to provide information to the creditors at all, then you are placing the adjudicators in the position of some sort of god with omniscience. And that, in my view, is really problematic. So I would say this is a real problematic feature that you highlight, Shashwat, on your account of the Indian process. I think this is problematic.
Okay, so thank you, sir. Thank you very much.
Pleasure.
Okay, we'll take a last question. This is the final question we'll take up. Prakul asks that in the draft regulations on connected party pre-pack, administrator may either take consent of creditors or a qualifying report may be obtained from an evaluator. On what basis does the evaluator provide a qualifying report?
Prakul, thank you. Did you read through the regulations on connected party pre-packs fully? And if you did you see how to assess whether the evaluator is duly qualified to provide a qualifying report. That was my favorite bit of any piece of legislation anywhere in the world, because the qualifications of the evaluator are that the evaluator considers themselves to be qualified to provide a report. So it's that sort of ridiculous, um, self-serving, self-certifying gateway, which is provided for the qualification of the evaluator. And I agree with you. I think that incentives, we always ask, in thinking about the design of legal frameworks, we think about the sorts of incentives which the law would create for the different stakeholders. And the evaluator has no incentive to develop a reputation for rigorous scrutiny of the proposal, quite the opposite. The evaluator has no greater incentive, no basis for accountability to the stakeholders or to the court than was the case with the Graham pre-pack pool participants. So it's a facade, and I think that this is just trying to hold up a facade which should be allowed to fall, so you can think of better, more appropriate, more credible responses to the pre-pack problem.
Yeah, thank you, Professor Mokal. And I think it was a very enriching discussion that we've had so far. And in most discussions that happen on insolvency, usually UK, US, Singapore are cited as examples. But I think very soon that will change, because the amount of progress that the Indian insolvency regime has made in the last 4-5 years, I think, is remarkable. So yeah, thanks a lot for for this session, and special thanks to all the participants. Making it more interesting. Professor Aurelio, it's always a pleasure to have you. Pulkit, Professor Van, thanks a lot, everybody. And Dr. Niti, any closing remarks?
Um, all I would like to say, Professor Mokul, it was truly an honor to host you today. And, India has, trying its own bit with MSME insolvency. It was to introduce a special insolvency regime, but it settled with a pre-pack regime. And I think as a young country, we are young democracy of young people, and insolvency regime is equally young. So I think we need experts like yourself to come and speak with us, so that we can do a lot of introspections internally and see what works best for us. So I know this is just the beginning of you coming to GIP, and I'm sure there'll be many more occasions. And I hope that when times are better, we could host you in person. Thank you so much for your valuable time. And as a UCL alumni, I would say that UCL has been one of the tallest institute when it comes to insolvency teachings. Being student of Iron Professor Fletcher myself, and I've not read from you, but today I got the honor to listen to you in person. Thank you so much for all your time, and for the knowledge of all our participants here. We will be putting up this video on our YouTube channel, and any further question that you may have, please feel free to send it over to us. And Professor Mokal, if you allow, I'm going to mail it to you, and see if need be, we could have another session, or at least we could give our, we could have some answers from you and put it in public for learning, so that there could be collective learning for all. And my special thanks to our friends, Professor Rello, Professor Van, Pulkit, and all the audience who joined in and stayed with us for long. And just to let you know, the next session starts at 5:30 with Mr. Mahesh Uttamchandani from World Bank. And some questions which you may not have found an answer here, uh, I think we'll just put to Mahesh. And Professor Mokal, thank you once again.
Niti, let me just say it was a real pleasure to participate in what turned out to be, in my view, a very high quality discussion. in significant part because of the quality of the participants and the questions put to me. I'm very grateful to you for inviting me, and it was a real pleasure to participate. And of course, I would be happy to receive further questions by email. So thank you very much, and I wish you, Niti, and Rustam, and the Institute, and all of the students present here all the very best.
Thank you so much, Professor Mokul. Thank you so much.
Thanks a lot, Professor Mokul.
And Rustam, thanks to you too.
Yeah, thank you, ma'am.
So see you all at 5:30.
Bye-bye.
Bye-bye.
Bye.